Good evening. Welcome to Aldersgate United Methodist Church. We're glad that you're with us tonight. Everybody here in person, we're glad to see you, and everybody who's also joining us online. I'm Carrie Beckenhauer. I'm a member of the Lasting Legacy team here at Aldersgate. We've been doing this presentation. This is our fifth one for this season. We will have a couple more yet to come that we'll talk about in a minute. A couple of housekeeping things before we get started. One is that the restrooms are out the double doors down the hall. You'll see the water fountain. Once you see the water fountain, you'll know that you're in the right spot. We also have emergency exits on every wall. We don't anticipate using those, but just in case, there should be one close by where you're sitting. If you brought in your coffee cup or your snack plate, that's fine. When you go back out, please take it with you. We have a tub for coffee cups and glasses across the hall where you picked your snacks up. So tonight, our speaker is going to talk for probably 30 to 40 minutes. After that, we'll do questions and answer. I'll bring around a wireless microphone because when we ask the question, the people at home need to hear it. We can hear it here, but we want them to hear it there too. So we'll use the wireless mic for that. Our speaker tonight has a great bio that I'm going to share with you. Brett is an estate planning and estate administration attorney for Ball, Loudon, Ebert, and Brostrom, LLC, of which she is a founding partner. Brett's practice includes estate planning, probate, estate administration, intellectual property, business succession planning, entity formation, and planning for charitable giving. Brett believes in presenting sophisticated legal solutions in an accessible, easy to understand manner. She is passionate about estate planning and the peace of mind a well thought out estate plan provides to clients. She has experience advising estate planning clients with a range of commercial matters, for simple real estate purchase agreements to contracts and intellectual property protections. Brett grew up in Lexington, Nebraska, where she worked at the local Dairy Queen, which was owned and operated by her family for more than 50 years. Please join me in welcoming Brett Ebert.
Thank you, Carrie, and thank you for having me tonight. I'm going to go through my PowerPoint. Normally I do say, ask your question as we go, but since we do want to make sure that everyone online can hear, I'll have you just hold your questions until the end, and then I'll hang around long enough that we get all of those answered. So, as Carrie said, my practice focuses primarily on estate planning and estate administration. So estate administration just means after someone has passed away, we work with family members to help transition their assets to that next generation or to whoever those beneficiaries may be. Our firm, Ball, Loudon, Ebert, and Brostrom, is a boutique estate and business law firm. That just means there's a lot of areas of law we don't do. We're very specialized in that estate and business planning area. So the first thing I always like to make sure people are aware of is that if you don't have an estate plan, if you've never done a will or a trust, you do actually have an estate plan. It's just that the state of Nebraska has actually written one for you. So what does that mean? That just means if you die without a will, you have died what we call intestate. And then the law goes through various different ways of how your estate would be distributed. One that I think surprises people and that we actually deal with probably the most often would be if you die without a will and there's assets in your name alone, those don't automatically go to your spouse if you have one. Those assets would actually get split. Your spouse would get the first $100,000, and then your half, and then your children would get half. Another one that actually has come up recently, we had a woman die intestate who was married, had no children. That meant her spouse got half of the assets, and her parents actually got half, which is causing now a little bit of complication. So what are the key components of an estate plan? The first is a last will and testament. I think everyone has kind of at least heard of that. The second is a living trust, sometimes, not always, but usually. Beneficiary designations, I consider part of your estate plan, and we'll talk about why. A durable power of attorney for finances, and then a medical power of attorney, which is combined with a healthcare advance directive. So before we talk about what does a will do, what does a trust do, I think it helps to get some definitions out of the way. So probate versus non-probate property. What does probate mean? Probate property is just an asset that would be subject to a probate administration. This is anything that might be in your name alone that has no beneficiary. So if you own a piece of real estate just in your name, that would be a probate asset. So at your death, nobody in the whole wide world has access or authority over that asset. So one thing that we are hyper focused on when we're doing estate planning is what your assets are, how they're titled, or what your beneficiary designations are. Non-probate property would be an asset that's not subject to probate. This would be an asset that is owned jointly with someone else or has a beneficiary designation. So if you have a retirement account that you have someone listed as a beneficiary on, that would be a non-probate asset. A really common misconception in the state of Nebraska is that if you don't have a probate, so if you manage to get all of your assets transfer through beneficiary designations or through a trust, and you know we're not going to need to involve the court when you die, people often think that that allows them to avoid the Nebraska inheritance tax on your assets. Unfortunately, that is not the case. So we'll talk about the Nebraska inheritance tax later in the presentation, but just know that avoiding probate in Nebraska does not equal avoiding our inheritance tax. So probate, just to kind of give you an overview of what that process looks like, takes about 9 months to a year, and that is assuming everything goes smoothly. And what do I mean by everything goes smoothly? Number one, if everybody gets along, so if we don't have any fighting over typically the stuff that we're fighting over isn't necessarily bank accounts or a brokerage account. It's really easy for me to split your brokerage account into three, between your three children. What is more difficult for me to split into three is your wedding ring or the grandfather clock or more recently the beer signs or what else were we fighting about? A coin collection. We can't always get that personal property equal. In fact, we never are going to get that equal. So we have some ideas to deal with that, but that can delay that probate time. And the reason it also just takes so long is because we have to do this kind of deep information gathering with all the financial institutions where you have accounts, and they, maybe not surprisingly, aren't super responsive to us usually the first time we write them a letter. Or we have to fax it this place or that place and try and get all that information gathered, so it does take time. Once you open a probate estate in the state of Nebraska with the court, you have to keep it open for at least 5 months. So the court won't even let us actually close a probate for 5 months. So that's the absolute minimum amount of time that a probate would be open. And then with that probate process, we are working with your personal representative or executor to help figure out where all of your assets are, getting them liquidated, transferred, consolidated. We work with that person to help pay your final bills. So that might be funeral, medical bills. Sometimes if you have any outstanding debt, we make sure that that all gets paid. And then once all that gets done, we figure out what you have and who it's supposed to go to, then ultimately things get distributed to your beneficiaries. So if all you have is a last will and testament for your estate plan, so you haven't done a trust, you just have a will, you are planning for a probate. Sometimes people think if I've done a will, I've avoided probate. That's not the case. A will actually contemplates that we would do a probate at your death, because your will means nothing, gives nobody any authority until we actually take it to court and have the judge say, yes, this is your last will and testament. That doesn't mean wills are bad. I still write a lot of wills, and we still plan to do a lot of probate. Probate is not the end of the world in Nebraska. We have an informal probate process, which means more often than not, we're not physically having to go to court. I'm usually not dragging your child or whoever you've named as your personal representative actually down to the courthouse to get this open. We do it all through electronic filing, but it does still have that time delay process. So what does your will do? Obviously, it's going to say where your stuff goes, so that disposition of your assets. We can do that a number of different ways in a will. They're still very flexible. We can do things equally to your children, unequally. We can build in right of first refusals. We can do a lot of stuff within a will. We also always provide for what we call a laundry list. This is a statement for personal property, like tangible personal property. This would be the stuff and the things in your home. So if your will says, I'm going to do a separate list outside of this will to deal with personal property, and then you do that separate list and you say, my wedding ring goes to this person, my grandmother's china goes to this person, and you sign and date that list, that is valid and enforceable. And you can change it without going back and seeing your attorney. You don't have to get that separate list notarized. So that can be a really useful document at your death to help avoid those disputes over the stuff and the things in your house. One of the most important decisions in your estate plan is going to be who is your personal representative, who is going to be in charge after you die. And we'll talk about this a little bit more later. And then if you have minor children or children that are subject to like a guardianship because they're incapacitated, within your will is also where we would name a guardian of those minor children. So a trust. A lot of times clients come to me and they say, I know I need a trust. Susie Orman said I need a trust, or I read on the internet that I need a trust. So what is a trust? A trust really at its core is a contract between the person that's creating the trust, we call that the grantor or the settlor, and the person who's in charge of it, who's called the trustee. A testamentary trust is just a trust that's tucked in under a will. So a testamentary trust would not be created, funded, it would not exist until your death, because then we take your will out and your will creates the trust. So most of the trusts that I'm creating and what I'm going to spend the most time talking about are living trusts. So this is also called a living revocable trust. If you create a trust and you put your assets into it, you are the grantor, so you're the person creating it, and you're the trustee, and you're the beneficiary. So as long as you're alive, anything you put in this trust is still yours. You're not giving it away. You're not giving up control of it. It's still yours. Just think of it like another folder or bucket where you might be putting your assets. The main reason that people like to do trusts, or why we do trusts, is to avoid probate. So if we create a trust and then we go through your assets and we retitle the way they are, or we update the beneficiary designations so that at your death, everything is owned by the trust or payable to the trust, then we can avoid a probate. That makes things go a lot faster when you die to get things to that next generation or your charities, whoever your beneficiaries might be. So that's kind of like the number one reason why people think of trusts. I think there's a couple other really good reasons why you should consider a trust-based estate plan. One of those is asset management. So while you're alive, again, you're going to be the trustee, which means you're in charge of the trust. But if you were to lose capacity, if you were to get diagnosed with dementia or Alzheimer's, or something like that, or just need a little help paying bills, whoever you've named as your successor trustee can actually step in and start managing your assets for you as your trustee within that trust. We have just found that a lot of financial institutions make it easier for the person who's acting as trustee for you to make decisions about your accounts, to get access to things, than they are with a financial power of attorney. So a lot of bigger financial institutions are just really reluctant to accept financial power of attorney documents, especially if they're older, and it can lead to delays or issues getting access to things for those people that you've named to help you with your finances. Another reason why I think a trust is helpful for lifetime management is we have been seeing more and more clients, or you see it in the paper like every week, people falling victim to financial abuse, scams, that kind of thing. If you have a trust in place and your children or the trusted, important people in your life start to notice, oh, dad's kind of doing some weird stuff with these checks that he's writing, we're not really sure if this is legitimate, it's really difficult to convince somebody that they've fallen victim to a financial scam. With a trust, your successor trustee could step in, become your trustee while you're alive, and now they are the only person with authority over your accounts. I know that sounds a little scary because it's giving up control, but if all we have is a financial power of attorney for you, that person is acting as your agent. You, in theory, could still walk into the bank and get money out of your checking account, even if your daughter is listed on there as your financial power of attorney. If that checking account was instead titled in your trust and she was the only trustee, now she's the only person who has access to that account. This is an extreme example, obviously. I've just about twice a year, we get a call from family members trying to figure out how to help mom, how to help shut off some of this access, and it's really difficult to do without a trust in place. Trusts can be revocable, which means you can change them, or they can be irrevocable. Again, most of the estate planning we're doing when I'm talking about trust is a revocable trust, meaning you can still change it. So you decide you don't want that child named as your successor trustee anymore, fine, we update the document, we take them out. Irrevocable just means it can no longer be changed. A revocable trust will become irrevocable at your death. So once you die, nobody can change what's in your document anymore. If we're doing an irrevocable trust for you while you're alive, that's usually because we are making a gift to someone else and we're doing it using a trust, or we're doing some long-term care planning. And I can answer questions about that at the end if we want to. That gets complicated. You can create a pet trust in the state of Nebraska. So if you have some furry friends that you want to make sure are provided for after you die, we can do that. If you have a beneficiary like a child or a grandchild, somebody who you want to benefit from your estate when you die, who qualifies for any needs-based government assistance. So maybe they're on Medicaid or they have some kind of special need. We always want to be very careful about how that individual is inheriting money. So we can use what's called a special needs trust. So we can leave them money in a special kind of trust that then that trust does not disqualify them for any benefits that they may be receiving. And then when they die, whatever money is left in that trust goes where you want it to go. Medicaid doesn't get to come in and get paid back out of that trust. So your successor trustee, similar to your personal representative, I would argue is one of the most important decisions that you're going to make in your estate plan. If you're going to name an individual in this role, it has to be somebody you trust implicitly. That is like requirement number one. I also really recommend you only name someone who's very organized, fairly sophisticated when it comes to dealing with attorneys, dealing with financial matters, interacting with accountants, financial advisors. And then another really important qualification, they should not be a procrastinator. There's a lot that needs to happen when somebody dies, and if someone is already prone to procrastination, and now we've put them in a role with deadlines, and throw some grief on top of that, and it can set up a really frustrating situation. Clients almost always in their minds default to, okay, I'm going to name one of my children in this role. And sometimes that's a great idea, and it works out really well. If they say that, though, then I kind of run through those qualifications, and then I also talk about the dynamic that occurs if you have more than one child and you name one of them as your personal representative or trustee, kind of your financial fiduciary, let's call them. Even if that child is doing everything exactly right, they're following all of our instructions, they're following all of your instructions, they aren't stealing, they're doing everything the way they're supposed to be, there's just this natural sibling dynamic that often bubbles up when mom and dad are both gone that puts that child who's in charge in a difficult position and often puts a target on their back. Everything they do gets questioned. People are just very suspicious. I'm an only child, so to be honest, I can't fully empathize with all of these dynamics that happen, but I've seen it. And even when I have mom and dad telling me, oh, my kids get along, that won't be a problem, that's usually not actually what happens. and it's not usually the children, I'll be honest, it's usually what we call in our office the outlaws or the in-laws, right? So it's not necessarily the brothers that are the problem, it's maybe the wives whispering in their ears. So those dynamics are tricky. Also, whoever you name in this role, you're not bestowing an honor on them, you are giving them a burden. And again, it's coming at a time when they're grieving, something terrible has happened, nobody's really being their best selves, and now they have to do this job that they've never done before. They're meeting with a lawyer, and it can be very overwhelming. So one option that I always encourage clients to consider is just remove the family dynamics from the equation entirely and consider naming a corporate fiduciary. So this would be a trust company. We are very fortunate in Lincoln. We have some great local trust companies that we work with almost every single day. Union Bank and Trust, First Nebraska Trust Company, and Pinnacle Bank are kind of the top three we work with a lot that are local, that I know I can get a trust officer on the phone right away if I need to. So what this looks like is at your death, there's somebody whose full-time job is to administer estates. They step in, they know exactly what to do, and we can really hit the ground running. People are often reluctant to name a corporate fiduciary because they're worried about what it's going to cost. Doesn't cost you anything until they actually have to serve. So until you're gone, or let's say we name one of your children, but we back them up with a corporate fiduciary. I like that plan too. Maybe we never need them. Great. Makes me sleep better at night though, knowing that I've got somebody to serve in everybody's estate plan should unlikely events occur. So I think that's a great thing to consider. I can almost guarantee that my fees are less when I have a corporate fiduciary serving than if I have an individual. And that's just because I don't have to spend the first 10 hours of our engagement just bringing them up to speed on what's even going on here. So yes, they charge a fee, but attorney's fees are probably going to be less when you die if you have a corporate involved. And your children get to remain siblings and children and friends, and if they're mad, I'd rather them be mad at Union Bank than each other. So, okay, so with trust, we always kind of warn against DIY estate planning. That probably sounds a little bit self-serving. Obviously, we'd rather you work with an attorney than go on LegalZoom or the internet to do your estate plan. We used to say, though, something's better than nothing, right? Like it's better to have something than nothing. That's really not true, actually. It is much worse and much more expensive to fix an estate plan that is wrong if you die than if you had just died intestate. So just proceed with caution if you're going to do it DIY. Oh, we already kind of talked about this. Okay, so ownership of property and beneficiary. So I had put beneficiary designations as one of the key components of an estate plan. And that's because if you go and you work with an attorney or you go online, you create a trust, and then you check it off your list and you say, I've done my estate plan. All you've done is step one. The really critical step two of your estate planning process is reviewing how you own your assets and what your beneficiary designations are. Your trust, once we create it, I create the Ebert Family Trust, that doesn't put anything in it. The trust will only control what we make subject to it. So in order for my house to be subject to my trust, I have to separately do a deed and transfer ownership of that house to the trust. It doesn't just magically suck everything in. We have to go in and put everything into it. So we spend a lot of time giving you checklists and talking through what your beneficiary designations should be or how your assets should be owned. Here's just some really typical types of ownership we see. So the first is joint tenants or joint tenants with rights of survivorship. This is probably how you own your home with your spouse if you're married. This type of ownership means if one of the owners dies, the survivor owns the entire thing. Tenants in common means each owner owns an undivided interest in that property. Probably once every couple of years, I'll be meeting with a widow or a widower to talk about their estate plan, and we pull out the deed to their house that they bought 60 years ago, and for whatever reason, they had taken ownership of that with their spouse as tenants in common. So that meant when spouse one died, spouse two didn't automatically own the home. Nobody did anything when spouse one died, because why would you think you needed to? But we realized in order to get spouse one's interest transferred to spouse two, we almost always have to do a probate. So if you have a house that you've owned for a long time, or even if it hasn't, and you know where your deed is, pull it out and make sure that it has this magic joint tenants with rights of survivorship language on it, especially if you own it with your spouse and that's your intention. If it's silent, if it just says owned by Nick and Brett, husband and wife, and it doesn't say anything else, that's tenants in common. Tenants in common, though, is a type of ownership that we will often see and recommend, usually between siblings. Like if you inherit a farm from mom and dad, most of the time siblings are going to take ownership as tenants in common. So if one of them dies, their 1/3 or 1/4 would go according to their estate plan. Payable on death and transfer on death designations, we use those interchangeably. Same with beneficiary designations. That just means the asset is still in your name, but you have that beneficiary or transfer on death designation on it, so that automatically at your death, that asset transfers. Sometimes clients avoid probate by just having beneficiary designations on everything. That is possible, and I'm sure it happens a lot more than I even see in Nebraska. That can work really, really well, and it can also work not so well. I am a proponent of having some kind of administration at your death, whether that's a probate or a trust administration. It sounds really nice in theory to avoid probate and avoid any kind of attorney involvement when you die by listing all 4 of your kids as beneficiaries on all of your accounts. And you can do in Nebraska something called a transfer on death deed. This is kind of like a beneficiary designation, but for real estate. So you could do a transfer on death deed for your house and list all your kids as beneficiaries on your accounts. Then the moment you die, those assets transfer. Great, that sounds super easy, right? Everything goes 4 ways. The problem with that is everything went 4 ways before we had a chance to pay bills, to pay for your funeral, to pay the Nebraska inheritance taxes that were due. So we have to hope that all 4 of those kids are aligned on, hey, we're not going to take this money and spend it right away. We're all going to kind of keep it together and use it to pay bills. So again, it sounds great in theory. It works really well if you have 1, maybe 2 children who you absolutely promise me get along really, really well. Otherwise, I really don't like to have a situation where I've got 4 siblings owning a house together in Lincoln, Nebraska, and we don't have one person in charge who gets to say, okay, here's the realtor we're using, here's when we're going to sell it, that kind of thing. Okay, so durable power of attorney. We're going to kind of switch gears here away from your death to your incapacity, and then we'll talk about taxes. So it's a fun night. So with your durable power of attorney, this is your financial power of attorney. You're naming someone to be an agent for you so they can act on your behalf with regards to your finances. Kind of already talked about this. Whoever you name here, you have to trust implicitly. If you want this person to be able to give away your money while you're alive, that is a power that has to be specifically listed. Your healthcare directive is very similar. We do these as 2 separate documents because often clients want different people managing their finances or making medical decisions for them. So your healthcare power of attorney names your agent to make medical decisions for you. It also includes what we call an advance directive, but people often refer to as a living will that says what you want to happen at, end of life regarding care and treatment. And then it also needs to include a HIPAA release. So if you haven't done your estate plan for a really long time and you did a medical power of attorney before HIPAA was a thing, you might want to look at this and pull it out and make sure that that's in there. So we'll kind of go over these tax considerations. Gift taxes I'll go through quickly. We'll quickly talk about the federal estate tax, and then we'll spend a little more time on the Nebraska inheritance tax. So that with gift taxes, unless you're considering gifting more than $15 million during your lifetime, you're never actually going to pay a gift tax. People often think if I gift more than X amount of dollars per year, we're gonna owe a gift tax on that. That's not true. The thing people think about, we call the present interest annual exclusion amount. So say that 5 times fast. It's currently $19,000 per person per year. So I could gift each one of you $19,000 and nobody has to worry about any kind of reporting or anything like that. If you gift more than that, let's say you're gonna gift somebody you wanna gift your kids $50,000. Great. All you have to do is file a gift tax return and just report that gift, because all you're doing is borrowing from your lifetime federal estate tax exemption, which for each of us, starting in January of this year, is $15 million adjusted for inflation. And so for a married couple, I know that I can easily avoid a federal estate tax as long as we're under that $30 million threshold. So for most of us, fortunately or unfortunately, we can keep your estate planning pretty simple. The only thing I will say about this is we have this mechanism called portability. So at the first death, for a married couple, if everything goes to the surviving spouse, that deceased spouse has used $0 of their $15 million exemption. If I'm worried about a federal estate tax at the second death, I will often go ahead and file a federal estate tax return for that first spouse within 9 months, so then I can port that first spouse's unused exemption to that surviving spouse. So portability, when we say a married couple gets $30 million of exemption, that doesn't just happen automatically. You do have to take action after the first death to file a return and get that unused exemption transferred. So maybe that's just a long way of saying at the first death, even though it feels like maybe there's nothing to do and there probably shouldn't be a whole lot to do, it is a good idea to meet with your estate planning attorney and just make sure. So let's talk about the Nebraska inheritance tax, and we'll go to current law since I'm worried I'm going to run out of time. So I'm going to make sure I leave plenty of time for questions. So the Nebraska inheritance tax is highly relevant. It affects almost every estate in the state of Nebraska because the exemptions from it are very low. Spouses are exempt and charities are exempt. So again, often at the first death, we don't have to do anything with the Nebraska inheritance tax. But at the second death, or whenever an asset goes to anyone other than a spouse or charity, we have to look at this tax. This tax is very unique in Nebraska because it is not taxed at the state level, it's actually assessed at the county level. So when we go to do an inheritance tax return, I'm not filing a return with the Nebraska Department of Revenue. That's not where the check goes. It's actually a judicial process. So it happens in county court. So if you die a resident of Lancaster County, the inheritance tax check at your death is going to the Lancaster County Treasurer. This is why it's going to be really hard to get rid of this tax. Counties really depend on this revenue for their budgets. So for deaths occurring after January 1st of 2023, here's how we look at this tax. So class 1 beneficiaries, this would be children, brothers and sisters, and anybody married to those people, grandchildren, they're considered close relatives or class 1 beneficiaries. Each of those people get the first $100,000 inheritance tax free, and then they're paying a 1% tax. So it's not a huge rate of tax for those close relatives, but that threshold, we can hit that pretty quickly. So usually we're paying some kind of tax. Class 2 beneficiaries are remote relatives, nieces and nephews, cousins, that kind of thing. Each of them only get the first $40,000 inheritance tax free, and then they're paying an 11% tax. Class 3 beneficiaries are non-relatives, like if you have a partner you're not married to, or just a friend you're giving money to, they only get the first $25,000 inheritance tax free, and then they're paying a 15% tax. Any interest going to someone under 22 isn't subject to tax. This is really important to deal with at death because if it's not and you own real estate, a lien attaches to real estate when you die. So kind of going back to my example of if we tried to avoid probate using a transfer on death deed and beneficiary designations, maybe that worked out really well. Your kids got access to everything right away. They didn't go see an attorney because they didn't need to, and they decided to keep your house together as a rental property. So they never saw an attorney when you died. They just owned the house, rented it out, and then 3 years later, they decide, you know what, it's time to sell. They're going to get a week out from closing, and the title company is going to come back and say, we can't close because there's an inheritance tax lien on this property, and it's been accruing interest and penalties for the past 2 years. So it's really important that this gets dealt with. So the federal estate tax, if one is due 9 months from your date of death. The Nebraska inheritance tax is due 12 months from date of death. And the way that we assess that tax is we essentially take a snapshot of what you owned on the day that you die. So we always say we wish estate planning could be more simple, but we don't know when you're going to die or lose capacity. We don't know what you're going to own. We don't know the value of what you're going to own. We don't know what the tax or other laws will be. We don't know if your primary beneficiaries are going to survive you. We don't know your order of death. And most of our clients are unwilling to commit to dying first to make things easier. So we have to kind of plan for everything. So estate planning, I already kind of touched on this. We don't believe it's a do-it-yourself process. There's a lot of little nuances that can get missed. People often wonder what value an attorney is adding. You're just filling in forms. Sometimes, but we like to think that what you're really paying for isn't necessarily the form that we give you at the end of the day, although obviously that's really important. It's the discussions that we have leading up to that form, talking through who is the most appropriate person to serve as your trustee or your personal representative. Have you thought about making sure all of your assets are going to get transferred to that trust if that's what you want to do? So we always recommend seeking competent professional help. We really advocate a team approach to estate planning, so we want to know who your other professionals are, and we want to make sure we're coordinating with all of them to get your plan working the way that we want it to. All right, now I think we've got time for questions.
On the Nebraska inheritance tax, what was the rate for a non-relative?
Non-relatives pay a 15% tax.
Okay, and that's the new rate after that date?
Yes.
Okay. Second question. Can the estate pay that tax for the person?
Yes, absolutely. And in fact, that's typically what happens. There's two different ways we can pay that tax. The default way of paying that, if you don't have an estate plan, is what's called equitable apportionment. So we look at who's generating what percentage of the tax, and they kind of contribute their share. The other and most common is we pay it out of the residue, so it gets paid off the top, and then we distribute the assets.
What county does the Nebraska taxes, is that like say somebody in rural Nebraska spends their whole lifetime out and then has a massive heart attack or something, goes in a helicopter to Lincoln or Omaha, what county is going to get that inheritance tax?
That's a great question. So we look at where you are domiciled when you die. And the way that we define domicile is where you have moved with the intent to die there. So it does happen that sometimes people will change their county domicile within the last couple of years of their lives, where maybe they've moved in off the farm and now they're in a skilled nursing facility or an assisted living facility in Lincoln or Omaha. If you still own real estate in another county, let's say somebody dies a resident of Lancaster County, they're domiciled here, but they own a ranch in Cherry County, we're going to apportion that tax between the counties based on the value of basically the real estate in that county. But to your point, that Cherry County may be lost out on a tax because somebody moved to Lincoln.
I have another question. On the beneficiaries, and there's like the first level is what designated beneficiary, and then there's contingent.
Mm-hmm.
Now, and in your beneficiaries, if somebody's, do they have to be living when you die? Or what happens if it's like designated between 3 or 4 and one of them's no longer? What happens down there?
Yeah, so the answer is going to be a very lawyer answer in that it depends. So, and it really does. It depends on often the contract that you definitely did not read with that financial institution when you opened your accounts there or signed your beneficiary forms. So if you have a beneficiary that's deceased, sometimes the financial institution, let's just say Vanguard, says, okay, if that 1/3 beneficiary is deceased, then their 1/3 would go to their children. That's usually what people would want to happen. Sometimes, John Hancock, because I know this happened, says that 1/3 doesn't go to this person's children, it goes to your estate. So then we have to run it back through your estate and divide it up that way. So it really does kind of depend. And we try as much as we can to control that or designate that when we're giving you instructions about filling out beneficiary forms. For example, if we have a married couple who has a trust, I'm almost always going to recommend that you have each other as the primary beneficiary on a retirement account, and then the contingent beneficiary is going to be the trust, so that we've already kind of planned for that. Which is also why I don't like to just rely on beneficiary designations to avoid probate, because it gets very difficult to control all these different levels of what ifs. Whereas if instead we're just sending that asset to the trust, I know in your estate plan, we've dealt with what happens if people die in the wrong order.
I had a few questions regarding the trust. And we spoke about the successor trustee to the original trustee versus the financial power of attorney. Who's first? In other words, when you have a financial power of attorney and you have a trust and you become incapacitated, who is first? Or whatever those conditions are.
So it depends on the asset that we're talking about. So if you have a trust, let's say we've only put your house into the trust and maybe a brokerage account, but then you have a bank account that's still in your name and you become incapacitated. Let's say you've named your daughter as both your trustee and your financial power of attorney. She's going to be putting on different hats depending on what asset she's dealing with. So if she's over here dealing with the house and the brokerage account that's in the trust and you're incapacitated, she's wearing her trustee hat. If she's dealing with your bank account, which is still in your name, then she's putting on her power of attorney hat. So it really depends on the asset. What we try to do, though, if you do become incapacitated, is in that power of attorney document, we give that person the ability to move your assets into the trust so that we can kind of get everything over here in this trust bucket and just make it a little easier to manage.
Okay, what turns the trust into the successor trustee into that role if you become incapacitated?
So our documents,
if there's a power of attorney sitting over here that says no,
yeah. So worst case scenario, we are having to get a physician, saying the determination that you're incapacitated. We don't always have to do that, and our documents don't require that, because sometimes it's questionable, but often it's not. It's pretty clear if we need someone to step in. Sometimes people are self-aware enough to go, you know what, I really probably shouldn't be managing my finances anymore, and they resign, and then we have that next person sign an acceptance, and then we give them a one-page summary that they can take around to the various institutions to show that they're the trustee.
Another question regarding a trust. I'm giving something to your grandchildren through the trust. But sometime in the future, you're not around, and they're still investing themselves, and they become whatever. They become a point where they have to have special needs. In other words, they become mentally ill prior to their full distribution. How does a special needs trust get created?
So we will, in our trust powers, we do include kind of a catch-all ability for the trustee that if we have a beneficiary who has a disability, the trustee has the power to essentially change how that money was going to be distributed to them. Because to your point, we can't predict the future, and people can develop, people can have accidents, like we just don't know. So we like to have that flexibility in there.
Last question. You didn't speak about small estate.
Oh, yeah. Yep. So a small estate in Nebraska is $100,000. So if the total value of everything in your name alone that does not have a beneficiary is less than $100,000, then we don't need to do a probate, and instead we can use what's called a small estate affidavit to take possession of that asset. Often, even if we've planned for a trust and we've done all the work to get everything into the trust, there's usually something hanging out there, usually a vehicle, that we need to use that small estate affidavit for. For real estate, it's also $100,000, which we have to use the county assessed value for that number. And the only thing we can deduct from that are taxes that are due and not yet paid. So if you have a $150,000 house with a $100,000 mortgage, so the equity is only $50,000, doesn't matter. I still have to do a probate for that asset.
When I created my will, I made no mention of what happens to the house and what happens to the car or the vehicle. How do I ensure that my house and my car or anything else, any other property, goes where I want it to go?
Yeah, good question. So which is pretty common. We don't usually actually list out specific assets and where they're going to go. Sometimes we do, like if you've got people have like a Corvette, they want to go to this person, we'll put it in there. We call that a specific gift. Otherwise, anything that's not specifically listed gets lumped into what we call the residue. So essentially it all goes into one bucket, and then your will would say your residue gets split, 50% between these two people. Or it often has language like to your issue on a per stirpes basis, or your issue by right of representation. And people pull their will out 30 years later and go, I don't even think my kids are in this. They are, because they fall under that definition of issue, which I think is kind of a funny way to describe our children as issue. But so anything not listed is going to be included because it's all going to get put in this bucket that gets split in your residue.
So that goes to probate?
It would probably, if all you have is a will, it would go to probate. Which, to be clear, probate still gets it to the people your will says it goes to. It's not gonna, sometimes TV shows go like, if you don't have a will, it goes to the state. That doesn't happen. It's gonna go to your beneficiaries. It just takes us a little bit longer to get it there.
Does that create more cost if it goes to probate?
So does probate create more cost? Yes. Probate administrations are expensive. There's attorney's fees involved. The court costs in Nebraska, as long as we're doing an informal probate, are not that bad. There are some states where the court fees alone are thousands and thousands of dollars. That only happens here if we have to do what's called a formal probate, which we'd have to do a formal probate if we can't find your original. So if it's been so long that you've done your estate plan and you've moved 3 times and you've lost track of those originals, it's probably worth it to just do a new one, to be honest, because it's very expensive to probate a copy of a will, or if the will isn't executed correctly. So I just had to open a formal probate for a gentleman because the 2 witnesses to his will were also supposed to get money under his will. Those are what we call interested witnesses. You should not sign a will if you're named in it, and that meant we had to go to court to get that one opened, and then it's going to be more expensive.
While you're talking about costs, can you kind of go over what a person would expect?
Yeah, it's a great question. So I think that I can tell you exactly what me and most of the attorneys at my firm charge. Most of us like to do estate planning on a flat fee. So as opposed to feeling like the meter's running every time you call me, it's just one flat fee. So for a will-based estate plan, it's usually a $1,200 flat fee. For a joint trust, for one couple or just one trust for a single person, is a $2,500 flat fee. Sometimes we have to do 2 separate trusts for married couples, and that's a $3,500 flat fee. So I would say $1,000 to $5,000, that's a big range, $5,000, depending on the complexity. And that's probably pretty typical in Lincoln. But always ask. Most attorneys who do a lot of estate planning do it enough that they can give you a pretty good estimate.
Now, if a person was inheriting something, does that affect their income for like their Medicare, IRMA, and all that?
That's a great question. Again, it depends on the asset. Most of what you inherit is not considered income to you. So if you inherit a house, if you inherit a brokerage account, that is not considered income. If you inherit a qualified retirement account, like an IRA, when you pull money out of that account, that is taxable income. The reason why houses, brokerage accounts, vehicles are not income is because of what's called the step up in basis. So if you have a farm that you paid $1,000 an acre for, and you know if you're going to sell it before you die for $8,000 an acre, that's $7,000 of taxable gain that you have to pay. But if you die owning that farm and it goes to your kids or whoever, we value that farm at your death at $8,000 an acre, so we pay inheritance tax, a 1% tax, who cares, on $8,000 an acre, and then if they sell it for $8,000 an acre, there's no income tax there, there's no gain. So we're able to really do a lot of efficiencies with income taxes at death, but with inherited IRAs, these rules are complicated, but kind of the most basic is unless you're a spouse, if you inherit a retirement account from someone, you now have 10 years to fully liquidate all of the money in that account. So if you inherit an IRA worth $1 million, you're going to have $1 million of income that you're going to have to recognize over that 10-year period of time.
Maybe time for one more question.
On the last one about the IRA, what if it's a Roth IRA?
So what if it's a Roth IRA? You're still subject to those same withdrawal rules, and that you can only keep it as a Roth for 10 years, but you don't have to pay income when you take it out because post-tax money went in, but you don't get to let it keep growing tax-free forever. We make you pull it out within, well, we don't. The federal government makes you pull it out within 10 years.
Anybody else? Oh, Larry, of course, has a question.
Two unrelated questions. One, have you ever had a surviving spouse survived, who may have been divorced, who were surprised when the beneficiary designation had not been changed by their husband, or some similar situation? I guess I'm wanting to impress, keep your beneficiary designation up if you're going to have a divorce or even otherwise, because other change of circumstances. And then I do have one other one.
Yeah, absolutely. So yes, updating your beneficiary designations, looking at those somewhat frequently. I strongly urge clients to do that. I remember one year for Valentine's Day, I made my husband sit down and look at all of our beneficiary designations together because he had started his first job before we were married. I wasn't listed as, he didn't put me down on his 401k. Why would he have? And then nobody goes to think of, you're not thinking about that as when you get married to now update your beneficiary designation. So absolutely. And if you do get divorced, we have a law now that says if you have a former spouse listed as a beneficiary, they're not supposed to inherit that asset. But I've had one this month where OPPD said, we don't care, we're giving it to her anyway, which luckily everyone gets along and the kids are like, whatever, but to fight that, like we could get it put back eventually, but to fight that would be expensive. So yes, review those beneficiary designations with some frequency.
Then the second one, have you had experience in working with anyone that has worked, that has Anatomical Gift Act designation, number one, and in that regard, you almost have a conflict because the folks with the the organ retrieval, they want this body to stay alive for a period of time so they can get to it. And on the other hand, your power of attorney for medical care may say, I want no heroic measures to be taken to keep me alive. Now, which one trumps the other? Because and I think I know, because in my will with you, we worked it out.
Yep. So there's two things there. With like organ donation, if I know someone's an organ donor, and I always ask, I do put it in their medical power of attorney. And also, this wasn't really your question, but helps answer it, I think. I used to recommend clients keep their estate plan private, and I still do to some extent, but the exception to that is that medical power of attorney. Don't let that be a surprise to the person that you've named in that document, that they're gonna have to make those decisions for you at the end of your life, and talk to them about, keep me alive long enough so that they can take my organs, because that's really important to me. Now, different is if you actually want to donate your body to science for research, like to UNMC. That is a different process that you have to do separately with that organization. And I've had it where they even make the spouse sign off on that paperwork before they'll finalize everything. We also can do body disposition affidavits. So if people want to be cremated or they have specific burial instructions, we will do that in a separate affidavit. I don't really recommend putting in your will that you want to be cremated, because people don't always look at your will before the funeral, so it doesn't always happen. So do a separate affidavit, and then you can also, in that document, name who gets to make the decision about your body, because if people don't agree, there's a statutory order of who gets to decide, and it might not be who you want.
Could you explain to me on the, like, SERPes, I think it's called?
Oh, STRPes? Yeah.
SERPes?
Yep. So it's a Latin word, and people sometimes think I've misspelled something, but issue per STRPes is just a distribution scheme. So let's say you have 4 children, and they're all alive, and your estate plan says it goes to my issue on a per STRPes basis. We split it into fourths. Great. If one of them dies before you, but they have children, their 1/4 would go to their children. If all of them were to die before you, and then we're still splitting it into fourths, and the children of this person share in a fourth, the children of this person share in a fourth, so it tells us at what generation we split the estate. We don't necessarily look for who's alive in that generation. We just know if you had 4, they all had children, and all these people die before you. We split it into fourths before we start splitting it. So that means that next generation could share unequally. If one child had 1 kid and one child had 2 children, the one with 2 children, they're only getting a half of a fourth instead of a full fourth. I mean, obviously it'd be rare for like all of your children to die before you, but it can be relevant. And we do talk about that. If you want it split at the generation where somebody is alive, that's different language. But most of the time we use issue per STRPes.
Okay, young lady, please join me in thanking Brett for being with us tonight. We hope that you'll come back next month. June 2nd is the first Tuesday. We will have Scott Wolf here from Wolf Professional Realty. He's going to talk about buying a house. And Brett might, well, you already got a house? No worries. You might have grandkids, you might have kids, you might have cousins, uncles, neighbors, somebody who wants to buy a house. They're not sure how to do it, or maybe you haven't bought a house for a while and you're going to move. So Scott will be here 7 o'clock, just like always, first Tuesday, June 2nd. I invite you to come back, and we thank you for coming tonight. We hope this was helpful to you, and we also thank everybody who's viewing online. We wish you a good evening. Thank you.